Hello, everyone. Welcome to Court with Krissy. You know who to call when your business friend with benefits relationship goes bad and requires a PPO? Judge Rossi, of course. He should be able to see who's blowing smoke. I hope you like it. Court with Krissy is now in session.
And this matter is before the court today for an evidentiary hearing / non-jury trial regarding Mr. Marshall's request that Mr. Blackwood be held in contempt of court for violation of this court's personal protective order. And so, counsel, would you place your appearance on the record at this time?
Yes, Your Honor. Victor Jimenez on behalf of the petitioner, Paul Marshall.
Very good. Thank you, Mr. Jimenez. And Mr. Blackwood, I see that you've appeared without counsel today. I take it it's your intention to represent yourself at today's hearing?
Correct.
Very good. All right. Well, the burden is on you, Mr. Jimenez. I do have an allegation here, a couple of them. One of that Mr. Blackwood remains in possession of a 2019 Jeep. Now that I guess when I read that initially, I viewed it as primarily a commercial or civil matter outside of, the scope of a protective order, because the Jeep is personal property. It's not real property, like he's prohibited to be at by the protective order. The second item, however, is that Mr. Blackwood changed or took control of the locks of certain property at which is leased only in the name of Mr. Marshall, and that would be a violation of the PPO. And that is the reason I granted a hearing on the matter, is I thought, well, that could potentially be a violation here. So why don't you lead us off, Mr. Jimenez?
Of course, Your Honor. Other than the facts mentioned by this court by Your Honor, a last thing I want to point out, other than the changing of the locks of property that belongs to Mr. Marshall, by my estimation, Mr. Blackwood is in violation of not one, two, three, but five different conditions placed on him, restricted by this court by your honorable judge under MCL 750.411H. The following are violations committed by Christopher Blackwood. Just to pinpoint, to go a little bit further back, Mr. Marshall applied for the ex parte PPO on 3/2/2024. This honorable judge, granted it on 3/4/2024. In 3/10/2024, Mr. Christopher Blackwood tried to enter the premises of Mr. Marshall's home in violation of appearing at the residence of petitioner, in this case, Mr. Marshall, entering onto or remaining on property owned, leased, or occupied by Mr. Marshall, sending mail or other communications to Mr. Marshall, and placing an object on the property owned by Mr. Marshall. Christopher Blackwood on 3/10/2024, around 8 p.m., went to visit Mr. Marshall's property in violation of his PPO. This occurred on March 10th. If your honorable judge permits me, I could ask Mr. Blackwood these questions directly, knowing that Mr. Blackwood would perjure himself if he lies, as I have the screen caps, the screenshots of the Ring camera depicting him showing up at my client's home, depicting him knocking on my client's home door, depicting him putting mail in my client's mailbox. All this again occurred in March 10th of 2024 in violation of not one, two, three, four, five provisions that he was restricted to do under the PPO, Your Honor.
Okay, well, and because this is in the nature, there's potential jail time, that is restriction of liberty involved. Mr. Blackwood has the right to testify or not testify, just as he would during a criminal trial. I am flipping through here so I can determine, if possible, the date that Mr. Blackwood was served with the original PPO. And I do
That was
see,
going to be my response, Your Honor, was that from the moment that I was served, I never went to his property.
you recall the date that was served? And I do have a date
I
here.
don't.
You know, I'm looking at the proof of service and indicating here by Jamie Weller, Michigan court officer, indicating service on March 12th of 2024. So that would be, in fact, after the dates of those 310 violations. So those weren't pled, obviously, as violations. I'm going to proceed only on the two that were pled as violations, the locks. And if you could make a case and convince me that the Jeep should be something different than a commercial dispute, I'll hear it. But I don't think the 310 violations are going to hold weight. So you may proceed on the others, though, Mr. Jimenez.
Yes, of course. The changing of the locks of property leased by Mr. Marshall. These changing of the locks also occurred in March in violation of also the provisions of PPO of holding any property owned, leased, or occupied by Mr. Marshall essentially in ransom. I also have evidence to show that these locks were changed, which stops my client from reaching his leased property.
All right. Well, let's hear that evidence then from your client and any other evidence that you're able to present.
Just a couple. I will ask a couple questions on my client.
Let me swear him in first. So, Mr. Marshall, if you please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth? You're muted on your side, Mr. Jimenez.
Yes.
Very good. You may proceed, Mr. Jimenez.
Mr. Marshall, can you state your name for the record?
Paul Marshall.
Can you spell your name for the record?
PAULMARSHALL.
And do you know why you're here before the court today?
Yes.
Why are you here?
For a PPO violation against Chris on the lease property of.
Let's talk about that property. Do you have a leased property in the address you just told the court?
Yes.
What's the property that's leased?
Bargain stop.
Bargain stop. Are you able to go inside and grab your property?
I am not.
Why are you not allowed to enter your leased
Changed,
property?
and I'm not able to get in there because of that.
The locks were changed. Do you remember when the locks were changed?
I can't remember exact date about it. It was right around mid-March.
Mid-March. And how do you know it was Christopher Blackwood who changed those locks?
So he's the only person that knows the code to it other than me, at least by my knowledge, unless he's told someone else, I don't know.
Now, can you describe to the court what this kind of lock is?
So it's a U-Haul secure lock. So it's like a 4-digit like letter code you can change and reset via a screwdriver.
So was the lock resetted?
That's what I'm assuming and guessing, yes.
Have you tried inputting an old password to go into the lock?
Yes, I did. It did not work.
Your Honor, I think that suffices.
Okay. Yes, that can be that can suffice. You can have some cross-examination questions by Mr. Blackwood. Mr. Blackwood, if you have questions, you should form them as cross-examination questions that would be answered by a yes or a no. I'll give you some leeway because you're not an attorney, but do you have any questions for Mr. Marshall?
I do. So Mr. Marshall said that he had a lease on this property, correct?
That's directed to Mr. Marshall?
Yes. A lease from the landlord to him.
Mr. Marshall, you may respond with yes or no.
Oh, yes.
Your Honor, I would like to mention that I do have an email directly from the landlord. After this was served on me for the violation, I got with the landlord and asked him what was going on with the lease because the lease is actually in my name, not Paul's. The landlord looked at this lease that Paul submitted to your court and immediately said, "That's not my signature. I have no idea who Paul is." He sent me over a copy of the original lease, who I am the only one on the lease, and showed me that it was actually, in fact, me and his partner on the lease, not even him. Paul forged this document to submit to your court. He
Okay,
does
do you
not
have a
have,
copy of what you're saying is the valid lease, Mr. Blackwood?
I do, I have it in my email, yes.
Okay, can you forward it to me or to my assistant via email?
Yes, right this minute.
Yep.
All right, let me see. Trying to see if I can find it right now. All right, here we go. I believe this is it right here.
Okay, double check, make sure you're sending the right thing.
Yep,
And then
that's
if
what
you can send that to Lee.
I do have it. Yep, I've got it.
Can we
V,
disable the chat at the orders of the Supreme Court because too much off the record the chat I don't think it's saved. So it was
I see.
creating a record problem. So we've been instructed to disable it and have done so. For court hearings, when we do meetings, other respects, we keep chat on. So, all right.
Your Honor.
All right. Well, Mr. Blackwood, so, you know, what I'm hearing from you is you've cross-examined Mr. Marshall on the lease. I note that Mr. Marshall did provide a lease. I believe it was either with a violation or with the original PPO. This one's dated this 15th day of December 2022 on its first line, but it looks like it was signed a different date. On one hand by Mr. Marshall with a printed name here on April 15th of 2023, and then Van Leer Tigis.
Judge or something like that.
Yeah, as the lessor, as
Yep, and
TMF
he is the
property.
one that he's the one that I got with and showed this lease to, and he immediately said he has no idea. That's not his signature. He's never met Paul. I'd like to note as well the copy I just sent to Lisa. You'll notice on the front page, it's between TMF Properties and HDK Properties, which is solely my business, not Paul's. It does not say bargain stop like the one he submitted to your court does.
Okay. All right. And so bargain stop is right, is the other party on the lease. What is well, I'll get it from Lisa here, and let's take a quick break while I take a look at that lease document. Okay, I've had an opportunity to review the lease. Mr. Jimenez, Mr. Marshall, when you're ready to return, we'll go back on the record and we can talk about the new information.
we are back on the record in the case of Marshall v. Blackwood.
Very good, thank you. And was there a question, Mr. Blackwood, that you asked regarding the lease that you just provided via email?
I guess there wasn't necessarily a question to Paul other than I just wanted it on record under the, I guess, a chance of perjury that he was admitting he in fact does have a lease from the landlord on this property.
And I think that you previously answered yes to that. Is that that's correct, Mr. Marshall?
Yes.
Okay. All right. And Mr. Jimenez, what do you make of the alternate, the earlier at least the one that appears to have a February 23 signature date?
Yeah, I have the one that was provided to the court, the 4/15/2023, with Mr. Marshall's name on it. Whether the person says that he's never met Mr. Marshall or et cetera, then Mr. Marshall's signature was put there fraudulently. And if it wasn't Mr. Marshall, there's only one other person that could have put his name fraudulently on this lease, and that is Mr. Christopher Blackwood. So even if Mr. Christopher Blackwood's argument is that that my client is not a party to the lease, um, which of course benefits my client because my client's off the hook of paying any kind of rental agreement, monthly agreement. That name got there somehow, some way. And the only person that would have the power to put that name, and I know my client's signature, and it does not look like my client's signature, the one we provided to the court on 4/15/2023. If Mr. Christopher Blackwood, and it is my estimation that he has done that, falsified documents in Mr. Marshall's name, then that is also a violation of the PPO. Because there's only one way that name could have gotten there. And according to Mr. Blackwood himself, Mr. Rossi or whatever his name is has never met Mr. Marshall and had never had a meeting to discuss the lease. And how did that name get there?
Yeah, okay. Yeah, no, I see what you're saying. All right. And well, Mr. Marshall, did you ever meet this lessor person, Van Leer Tigges?
I did not know.
And how about there's another name that's signed, it looks like Samuel Fazlick maybe on the earlier? Earlier lease document, did you ever meet that individual?
I did not know.
Okay, and I mean, to your recollection, did you ever sign a document making you the lessee, the sole lessee of those premises?
I did not know.
Okay, so if that appeared on there, it was signed. So did you give Mr. Blackwood permission to sign your name for you to a lease for the premises?
I did not.
Okay, did you give anyone else permission to sign the name for you?
No, sir.
Okay, so you don't know exactly how it got on that lease. Now, the lease that was just provided electronically by Mr. Blackwood does list you and Mr. Blackwood as the principals. He's the registered agent, but you're both listed as representatives slash affiliates of the lessor in that case, which I think is HDK.
HDK Property Services, yes. If I may comment on that a minute, Your
Well,
Honor.
I'll give you a chance, Mr. Blackwood.
Okay.
Let me get my questions in for Mr. Marshall, and then I'm going to turn to you and kind of get an answer and see if this is something I can rule on. So,
Okay.
are you a partner with Mr. Blackwood in HDK Property Services? And that's to you, Mr. Marshall.
No.
Were you at the time of the lease signing back in that one looks like it's dated February 14th of 2023? Were you a partner or
No.
a co-investor?
No.
Okay. What was the relationship at that time between you and Mr. Blackwood, if any?
Friendship. Trust.
Okay.
Trustworthy friendship.
All right. So if you were listed as affiliated with that HDK Properties, it was without your permission?
Yes.
Okay. All right. Well, I think I have a kind of a basic understanding of documents and what has happened here. And so I could summarize then, Mr. Marshall, your allegations are, well, I was friends with Mr. Blackwood. He, without my permission, listed me as a principal or someone related to HDK Properties, Inc. when he signed this lease in February, and then he took it upon himself, or someone else did, to sign an individual lease subsequently that year in April, making you the sole lessee of the property. And that's what you're trying to enforce right now, is you're trying to say, hey, if I really am the lessee of the property and I have rights to access that property and do stuff on it, then let me into it and let me take my stuff and make it a running business or whatever I'm going to do with it. But right now I can't get there because I'm locked out.
Correct.
Okay.
It's
All right.
Oh, one last thing, Your Honor, if I may. It's important to note that my client has made complaints to the police department and in his PPO of discovered social security, stolen social security number, forged documents under his name as well.
Okay, right. And generally, of course, those things could be potentially uh evidence supporting or violations of a protective order, of course. But generally, a matter, for example, identity theft, there's a financial loss or whatever, that, I allow those are handled separately through law enforcement. I don't pursue them through the PPO. And in fact, my feeling is if there's an open law enforcement investigation or, charges that arise out of something like that. Sometimes the PPO has to take a back seat because it's a civil action and at the end of the day, a contempt action and obviously a criminal case of any sort's more important in my estimation. So, do you have
And
any idea, Mr. Jimenez, of the status of the criminal cases as we sit here?
No, Your Honor, those are still being investigated and are pending. But I also would like to know that if his name is on the property lease, which it is, fraudulently or not, that puts my client on the hook for that lease. That puts my client on the hook for anything inside that property, Your Honor. And if it was done fraudulently, then that's criminal. If my client is to be on the hook for his names being on these leases, then the change of the lock is the violation in itself. So either
Okay.
way, it cuts both ways into my argument, Your Honor.
Yeah, well, and I do want to give Mr. Blackwood an opportunity to make a statement under oath here. And one of the things, if he does renounce the validity of um, the April 15th lease, then, he's the one that's the signatory as the agent on the prior lease, and it's his baby and not yours. And of course, he would then have the opportunity, then he would have the ability at least separate some other agreement, perhaps to change the combination of the lock, but he'd also be liable for the monthly rent and things of that nature. So I guess I want to give Mr. Blackwood an opportunity to clear that up. So, Mr. Blackwood, if you would raise your right hand, please. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
It is.
All right, very good. And Mr. Blackwood, what's your side of the story regarding the two leases that exist in this case?
All right. So the first one, Your Honor, he was on it as a representative because me and him were going to go in to the store together. We were going to lease the store together. I later thought about it and decided I did not want him on the lease. So that's why my signature was on it. His was not. He didn't actually sign the lease. Therefore, he took no responsibility of it. We were done with it. It was my store. I've paid the rent by myself for the last year and a half. He's paid $0. So it's been zero his responsibility.
Okay,
The
so you've
second
been
lease,
paying up to currently, you've been paying the rent that's been due on that property.
correct. I've been the only one that's paid the rent.
Who's the person that signed that FASLIC? Who's that person?
Which one?
That signed the February document. It looks like maybe a
That's Sanel.
Who is that in relation?
He is one of the
to that?
owners of the property. There's two owners. Sanel is one of them, and Tajaj, or however you pronounce his name, is the other owner.
Okay, and the two of them are TMF properties, and they both have
Correct.
Okay, signature authority of some sort. And
Yeah.
I guess this does tell me that you're the registered agent. You're the person that's filed the documents for the other corporation there, which is HDK Property Services. Okay, all right. And
Yes.
your argument as we sit here today is that's your lease.
Yes. That he had no lease there. The lease that was in April. First of all, I mean, that argument doesn't even make sense to me. If he just said on oath that he had a lease, why would you say yes if you assume this lease was fraudulent? If you never signed it, that doesn't make sense. Why would you submit it to the court as a violation on my behalf if you felt the lease wasn't even true and you had no recollection of the lease? Why would you
It
even
sounds like
present
he
that?
thinks he's stuck with it, stuck with the lease, and I guess I'm hearing you today say that as far as you're concerned,
He has
that
nothing to do with the
415 one
lease.
is no force in effect.
Correct. It's fraudulent. He also just said to you
And
that
you're
our
not going to
relationship.
cop to fraudulently putting his name on there, I take it, because obviously that would open you to, potentially a can of worms if it was others' permission. So you're denying that it was you that put his name on there.
I mean, why would I want to give him a lease to my building? That doesn't even make sense to me.
Well, I can think of about 10 reasons. If business was going a little bit south and I didn't want to be on the hook anymore and I wanted to hand it off to a nominal partner, I might think about doing that. If the partner was, thought he could make a go of it and it would extricate me from it, there could be 10 different commercial reasons.
Yeah, no.
It's not why we're
No.
here. In any case, you're just saying you
Nope.
didn't do it.
Correct. He also
Okay.
just a moment ago told you that at that time of signing on that lease, that our relationship was strictly friendship.
Yeah.
But yet I have a contract in front of me, a letter of intent on February 1st of 2023 that me and Paul Marshall entered into on behalf of the business at Bargain Stop, on behalf of the business at Mrs. Bubbles, on behalf of the business on a few different things on February 1st. He was a partner in the business. That's why I considered putting him on the lease at first. And then I reconsidered that because I didn't really know him quite well at that point. We had just met 6 months prior. I didn't really know much about him, yada, yada. So I backed out on putting him on any leases. I made this agreement to him that if he made certain obligations or he met certain obligations, certain milestones, he would be allotted half of the business or a certain percentage, yada, yada.
Okay.
So at the time that lease was even signed, the original lease, our relationship was beyond just friendship.
Okay. All right. I got you. All right. Any questions for Mr. Marshall, Mr. Jimenez?
No, Your Honor.
All right. And any
Your
follow?
Honor, if I could ask him one more question to Mr. Marshall
Yeah, go ahead.
regarding the leased vehicle. Were you not at any point selling that vehicle to me prior to this PPO order?
I was never selling you a vehicle, no.
So we never had an agreement for you to sell me that vehicle?
Nope.
Your Honor, I'd like to also mention that I have a document here that was notarized in present of the bank teller right at Mr. Marshall's bank, notarized and signed between me and Marshall. It's a letter of assumption, a lease assumption agreement signed on December 12th of 2023, stating that Mr. Marshall was selling that vehicle to me, that I was to be making the payments on it. He leased the vehicle December 11th. And the only reason he leased it was for the sole reason of me purchasing it from him. We immediately signed that document. I have that paperwork here as well that I can submit.
Okay. Well,
Showing
you know what?
just
These are
another document showing that he had signed and is now saying that he didn't.
Okay. Yeah. No, I understand. Well, and I mean, what these are all documents are, tending towards. Well, let me, Mr. Jimenez, do you have any follow-up questions for your client or follow-up testimony from Mr. Marshall?
You just heard what Mr. Blackwood said concerning some kind of agreement for the vehicle. Can you tell the court your version of the story?
So essentially, he's saying I sold him a lease, which is not the case when I still have a lien of the loan holder of the vehicle with a separate bank. That's completely different than what he's trying to say that was notarized, which is
Well, did you
essentially
sign it? I guess the question for you, Mr. Marshall, did you sign a document where he would assume the lease payments?
out of coercion. Yeah.
Okay, well, but nonetheless, you signed it. If it's got your signature on it, then you're kind of stuck with it. Well, and you know what's emerging to me here, it just parenthetically is, it's a picture of, more so than a case that's appropriate for a protective order. It's a civil case. It is at least a contemplated business partnership that potentially involve several businesses. And I had this bit of caution as I stepped into this case and signed the original protective order in the first place. And that normally if something's a civil lawsuit, I say, hey, it's a civil lawsuit. It's not a protective order. And in fact, in those cases, sometimes a protective order is harmful because if there's a deal that can be worked out financially between the parties, it's helpful for them to be able to at least communicate with each other by correspondence or letter or something like that. And I just, based on what I've heard today, I can't find the violations of the protective order. I simply can't find anything, I can't determine which lease is the legit one or who signed what. It appears to me that Mr. Blackwood is more than willing to denounce the, April 15th lease here on the record and say that one is of no force and effect that went to you, whoever signed it. And he is disclaiming that, of course, that he signed it himself. So, without the knowledge of, who really owns that property, then I can't make any determination of who should have day-to-day access to it. In other words, that would be a matter, for a civil court to determine via the contractual relationship between the parties, but not a lease. And of course, this place is a business. It's not a residence. In some ways, a residence is a little easier to determine. Not always, who's the really true owner of it and who's living at the premises. And, if you can be protected there, this is at the end of the day a business premises where someone's incumbent to pay the rent on it. And also, if they're going to run a business, they go in there and they run the operations of the business, buying, selling, whatever occurs there, so that cash keeps going through the door. And at the current time, it appears that Mr. Blackwood, at least in terms of the lease, has assumed the responsibility for the paying the lease on the premises and owning it, the responsibility therefore. So I can't find that then him locking you out of it. It may be a violation of your contract or your partnership agreement, but I can't find that it is a violation of the protective order and that it's not keeping you from what I can definitively say is your property. It appears rather that he's saying today, and you're acknowledging that it's not your signature on the actual lease document, that it is in fact his leased property, and that therefore he has the right to, make lock changes and things of that nature on there. So I can't find a violation of the protective order based on that. And the same would be true, with, as I said, the protective orders, at least in my mind, cover real property. And that when they say you can't be present on or near the property of the person protected, well, it doesn't mean every piece of real property, their vehicle, their gas grill, their boat, their things like that, but it means more along the lines of a residence where that person lives. And that's to give, of course, the person living there the assurance that, they're not going to get a midnight unwanted visit from the person that's been stalking or harassing them. But that doesn't apply in a case like this, where there's really essentially a partnership or commercial dispute over who really has rights to the property, in this case, the Jeep. And what I'm hearing here is there might be competing documents. You might have purchased it. There may be a lease agreement at some point, coerced or not. You did allow, Mr. Blackwood to sign off and assume payments for the lease. And if you did that, well, then he might also reasonably have concluded that he, if he's paying the lease, that the car is, he's able to be the driver of the car. And like I say, the relationship there is beyond what I can discern under the scope of the protective order. So my advice here, I'll leave the protective order in place. I see here, I did sign this. Well, let's see if I signed it back in March. We're probably on with the terms of it, until September 4th of this year. But I would recommend bringing these matters, if there's a legal solution it's to be brought in a civil lawsuit along the lines of a breach of contract, breach of partnership agreement, something along those lines, rather than necessarily a protective order. I don't think, all the protective order really is designed to do is keep the two of you separate from each other and safe in your own homes and property. It's not designed to reconcile these complex contractual and business type interests that we're talking about here. It's ill suited to that. So I'll leave it in place for the time being. I'll find no violation at this time. However, I would encourage you to, this being Mr. Marshall, to seek a civil remedy. I think that's more along the lines of what you're looking for here. I can't via the protective order, I can't give you ownership or, exclusive rights to use a property if there are competing leases, and the same, very true of the vehicle. I can't give that back to you under these circumstances either. So I'll deny the violation at this time. And the protective order does remain in place until September. Encourage the parties to seek some sort of civil resolution of the dispute in this matter, so that you can both get on with your own business and personal lives going forward. So,
Your Honor, may I
Thank you,
ask
Your
one
Honor.
more question of you?
yeah, go ahead,
This
Mr. Blackwood.
PPO order works both ways, correct? He's now obviously agreed that he has no lease over there. That's my property. He can't just show up and try to enter the property or anything under that protection order as well, correct?
Well, I'm glad you asked. And no, the answer is it doesn't work both ways. You're not protected against Jim because you didn't file it for a protective order. So he, for example, if he believes he has a contractual right to be present at that property, either with you or without you there, he might. It would be the only answer I have. And again, that's a matter for a different lawsuit to resolve who has the actual rights to operate the business and enter the premises there. I've ruled today that your lease that's in your name is valid, giving you, but that lease does have his name on it as well, implying that, at least at one point in this process, he had some sort of interest in the business, but that's beyond the scope of the protective order for me to sort out. So again, I would encourage the two of you to sort that out either with a business resolution, just get it in writing with both of you signing it. A lawyer or two looking it over never hurts to make those things more final and and then put the thing to bed. But I'm not going to be able to do it in the context of a protective order.
All right, thank you.
Thank you.
Thank you. Have a great day, Your Honor.
Thank you.